Welcome to You Counsel. This is our third lecture in this series where we had initially raised this question whether tort liability in the real world could arise because of a wrongdoing in the virtual world. And in the first two lectures, in the first lecture, we sort of set out the discussion. We talked about what is virtual reality and augmented reality and how human beings interact with those kind of issues in the virtual world. And then in the second lecture, we discussed whether the harm that may be caused by a misconduct in virtual world, could that harm be real? Could it have real implications on people in the real world? And we talked about it, and we concluded our second lecture with sort of coming to that conclusion that at least the mental harm, the mental trauma could be real, if not the physical harm. And then we sort of discussed that we should consider the possibility of a tort action and go through all of the elements of a tort action, not just the damages part, and see whether there is a potential tort liability that may come. So in today's lecture, we will then get into the discussion of the factors of tort of negligence and apply those into the virtual world and see where it takes us with respect to any potential liability. We begin with our disclaimer that this lecture is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for any referrals. Now, I have posted previously a lecture on torts of negligence, and I have described the elements of tort of negligence in detail. If you have no understanding of tort of negligence, I will encourage you to review that lecture first so that you have some basic understanding, because I will not go through all of the elements and explain those in detail in today's lecture. We'll just go through those elements in today's lecture. Now, there are 5 elements of tort of negligence. Number 1, the defendant owes a duty of care to the plaintiff, so there must be a legal duty. It's called a duty of care, and the court should impose that duty. If there's no duty of care towards the plaintiff, then there will be no claim for negligence. Number 2, whether the defendant breached the standard of care with respect to that particular duty, so it's called the reasonable person standard. That is the second element. Number 3, did the defendant's breach cause the plaintiff's injury or loss? It's called causation. So was the loss caused by the defendant's breach of its duty? Number 4, was the injury or harm, the damage that was caused to the plaintiff, was that foreseeable? So this is also called the direct connection between the breach of duty and the harm. So it's also called foreseeability or direct connection test. And the 5th element is that did the plaintiff actually suffer harm or loss, which is damages, and that's something that we had covered in our previous lecture. Now, duty of care is, in our scenario, with respect to the virtual world, is sort of the most important element of tort of negligence. My understanding is that so far, there has not been a duty of care imposed on the online gaming industry. And so we'll talk about that and figure out whether when these cases arrive at court, whether the court will consider imposing a duty of care or not on the online gaming industry, on the providers of virtual world, virtual reality and augmented reality. So as I said, duty of care is fundamentally an obligation not to harm others or their property. A very common example of this duty of care is when we drive our cars on the road. You and I, when we are on the road, we owe a duty of care to other drivers in other vehicles, to passengers, to pedestrians, and to their persons and their property. So that's a duty of care. We don't have any contractual relationship with other drivers on the road. So this duty is imposed by law on us, and it applies to everybody who is driving a vehicle. So that's an example of a duty of care that is imposed by law. And so courts impose this duty. There are some known categories over last 100 years or so that have been developed with respect to duty of care. And a common example is a doctor's duty towards his patient, a lawyer's duty towards his client, an accountant's duty towards his client, a manufacturer's duty towards the consumer. And this has been established. It's called product liability. Every time a manufacturer creates a product, the manufacturer has some obligations, duty of care towards the consumer. So this is sort of well established. And what we will argue in our situation is that the manufacturers of the virtual world, do they have any potential duty of care towards the users of that virtual world. So when a court is considering whether to impose a new duty of care, there are certain factors that the court considers in deciding, and we'll talk about those factors. And remember, in my first or second lecture, I had mentioned that one of the reasons why we're talking about tort law in this case is because tort law has this capacity to evolve as the society changes, as the technological advancements happen in that society and other advancements happen. So in this case, we're going to consider whether the court will be willing to impose a duty of care towards the providers of virtual world, towards people who use the virtual world to commit any wrongdoings virtually. Could there be a duty of care imposed or not? So what are the factors? One factor that the court will consider is foreseeability of risk or the manner of injury. What do we mean by this foreseeability? A simple example is that when you're driving your vehicle and you apply the brakes, and if the brakes don't function at the time that you want them to function, it is foreseeable that you will have an accident, and that accident may cause you injuries. So there is a risk that is foreseeable when a brake will malfunction or not function when you're driving a vehicle. It is foreseeable. So foreseeability is sort of the possibility of a risk and the manner of injury that may cause. Second thing that the court will consider is the court will analyze any legal relationship between parties. So in our example of driving cars on the road, there is no legal relationship between the parties. There's no contractual relationship. But in many cases, there may be a contractual legal relationship between parties outside of the duty of care that the court is thinking of imposing. So, for example, in a lawyer-client relationship, they will have a contract between the parties, a retainer agreement, which creates a legal relationship between parties. Similarly, when we buy products, it is a contract, right? We purchase whatever item, whether it's car or a motorcycle or a toy. We have a contract with the manufacturer, with the seller, and there is a legal relationship. So the court will analyze that legal relationship in deciding whether that legal relationship plays a role with respect to imposing a duty of care on the defendant. The court will also consider likelihood of the injury. What are the chances that this particular the particular fact may cause an injury to a person? And then court will consider public policy with respect to who can bear the loss due to that injury. So, for example, in a motor vehicle accident, if a person becomes paraplegic, now that person has some burden on the society at large. And so the court looks at the overall sort of social circumstances in determining who bears the loss with respect to that injury. And this is sort of the old Greek concept of distributive justice, that when the harm has occurred, how do you distribute the justice across different sections of society so that the burden can be borne by the society at large or by parties who have the capacity to bear the burden. And finally, the court may consider other policy considerations in deciding whether a duty of care should be imposed or not. Now, let's look at whether a duty of care has been imposed in video gaming industry or in online industry so far. And one example that I can quote you is that one person, she was following Google Maps instructions and driving on the road. And while following that instructions, the instructions on the Google Map was for her to cross this busy highway, which was an incorrect instruction. And as she did so, an oncoming vehicle struck her vehicle and she got injured. And so she brought this lawsuit against Google. And that was in 2011, I believe, in Utah. And in that case, the court found that Google did not owe any duty of care to that person. And what was some of the reasons? The court indeed acknowledged that the accident was foreseeable. When you follow Google Maps instruction and you end up getting a wrong instruction and you cross the street incorrectly, then it is foreseeable that you will get into an accident. But the court held that the person was ultimately responsible for their own safety. So they should have looked after their own interest and seen the road or had some visual understanding of the circumstances and looked after their own safety. So that was one reason given by the court not to find duty of care. Another thing that the court stated in that case was that imposing duty to warn users of all traffic hazard will be difficult, if not impossible, for Google. So that was another reason given. And finally, you can imagine that the court may apply similar principles in the VR and AR world. And if you are, for example, wearing VR headsets, and then you walk around in your room and you run into a wall, or you run into furniture, or you fall from the staircase, the court may very well apply the same principles and say that you're responsible for your own safety. You are in the virtual world, and you should know your surrounding circumstances, real circumstances, better, so that you don't get yourself in those kind of injuries. But the problem I put to you is that these arguments, these positions that have been advanced by the court in this particular Google case can go both ways, really. And in the past, we have seen these kind of examples, like when, before the tort law was introduced and created, the common defense for safety issues was that you should be responsible for your own safety, right? And so, but then the tort law evolved, and in so many cases now we say that manufacturers are held liable for the safety of users. And so the tort law has evolved in that case. Now, remember that, for example, we take an example of an electric saw. You're using the saw to cut wood, and if you put your hand at a place where you should not, and as a result your finger gets injured or cut because of that electric saw, yes, we can argue that you are responsible for your own safety, and you should know how to use that equipment. But if you are using the saw properly and your hands are placed properly, but for some reason the saw malfunctions and blade comes out or comes out of the saw and it hits your hand or finger and then causes an injury, now that's a malfunction of the equipment, right? And so in that case, why would the court say you should be responsible for your own safety? Now, applying that example to our Google case, if that person was correctly following the instructions provided by Google Map, and then she simply followed those instructions, then to sort of say that you should be responsible for your own safety, it's kind of the same argument that we have already rejected in so many other tort cases where manufacturers were not online gaming or not online providers, but they were providers of real equipment. So the argument is a bit difficult, and then if you are a driver like me, when I initially started using Google Maps or any other assisting devices, navigation devices, every time I relied on an instruction, I would sort of counter-check it. I would, with my visual sense, because I was reluctant whether I could rely on this particular tool that was given to me. But as the time went on and I became more dependent on that tool, now I'm less reluctant to rely on that tool. And there are certain times that I will rely on the tool, on the Google Maps, more than and then trying to figure out visually whether the instructions is correct or not. And remember, you may be driving at 100 kilometers plus an hour, and if you are required to check whether the instruction that is being given to you by a device, electronic device, is correct, and you have to check it by your own senses, I think imposing that sort of obligation on a driver may be too much. And not to forget that we are now entering into the world where we will be using self-driving vehicles in the near future, where you abandon all control to the devices, all control to the equipment that you're relying on. So I do think that not imposing this duty is sort of, it depends upon the time. The more accidents we may have in the future, the more issues we may have in the future, and the more arguments we hear, the more data we see, the courts may be more willing to consider that a duty is appropriate in the circumstances. And with respect to warning the users, again, it is also technology dependent. In 2011, there may not have been sufficient technology where the Google Map may be able to warn you of all traffic hazards. But in 2020 or in the coming years, the technology may be advanced to a level where it is possible to issue those warnings. And remember that in this case, the issue was not that the person got her vehicle got into a pothole that the Google Map could not warn her. It was the wrong instruction given to her. She should not have been sent to a highway which was a busy highway. So I think it's a different kind of scenario. But again, it depends upon the scenarios. And again, when you apply this in virtual world, now the same arguments can apply, right? When you use virtual world, one of the features of virtual world, one of the attractions of virtual world is that they want you to be immersed in virtual worlds. A good virtual world will make you forget the real world. It will make you be detached of the real world, right? And so if the purpose of the virtual world is to make you detached of your surroundings and detached of your real world, and if there is an injury that may be caused to you from the real world, why couldn't there be a liability? Why couldn't there be a duty of care? Why couldn't there be a duty to warn that on the virtual world providers? So I think those are the kind of discussions. You may disagree with my points, but those are the kind of discussions that will take place in the coming years in the courts, and it will be interesting to watch whether the court imposes a duty of care or not. Now, as I said, duty of care is sort of the biggest hurdle in this case, and once the duty of care is shown, is found, then it will be relatively easier to sort of find potential liability. But in the next lecture, we will go through other elements of negligence and see whether in our discussion, in this analysis, we can find any duty of care against the virtual providers of the world and the people who are using that virtual world to commit some virtual acts or virtual wrongdoing. Thank you for watching and stay tuned. We will be back with the next lecture shortly.